Good afternoon, everyone. Welcome to the latest installment of Civil Disagreements that is presented by several organizations, sponsored in part by the American Bar Association, specifically the American Bar Association's Division for Public Education, whose their mission is to educate the public about law and why it's important, co-sponsored by the Chicago chapters of the American Constitution Society, as well as the Chicago Lawyers chapter of the Federalist Society. There's also the Chicago Council of Lawyers and Courts Matter Illinois and Reform for Illinois. And moderating the panel this afternoon is the Executive Director of Reform for Illinois, Elisa Kaplan. And before we get started, we're going to just a couple of housekeeping reminders. We're going to put a link to the materials in the chat. It's a Google Drive folder, and you're welcome to open it and use things as you need to. And then this program has been approved for 1 hour of CLE by the state of Illinois. So there is an evaluation form that will also be put in the chat toward the end of the program. And it'll also be in the email that goes out tomorrow. So be sure to fill that out and have your ARDC number so that Reform for Illinois can make sure that you get the certificate for that credit. So, all right, we are going to get started.
Thanks, Tiffany. Hi, everyone. Thanks for joining us. My name is Elisa Kaplan, and I'm the Executive Director of Reform for Illinois. Reform for Illinois is a nonpartisan organization dedicated to improving government through ethics, campaign finance, and election reform. We are so excited to have two distinguished debaters today, Professor Steve Schwinn from the University of Illinois Chicago Law School, and Ilya Shapiro from the Manhattan Institute, to discuss this extremely timely and important topic: the unitary executive theory, legitimate constitutional theory, or path to dictatorship. The format of the debate is going to be 13 minutes. Each participant will have 13 minutes to give their opening statements, and then 3-minute rebuttals. And then after that, we'll open the floor to discussion and debate. And we will end at between 1 and 1:15 p.m., depending on how our time goes. The unitary executive, I'm just going to give you a little description of it so the debaters don't have to get into it. The unitary executive theory asserts that the president holds sole executive power over the executive branch of government, including directing officers, controlling information, and hiring and removing personnel. And it's that removal power that will be especially relevant today. Critics argue that it undermines the system of checks and balances as outlined in the U.S. Constitution. Proponents argue it increases accountability and efficiency. So, without further ado, I would like to hand the conversation over to Ilya Shapiro, who will be arguing that the unitary executive theory is a legitimate constitutional theory.
Great. Over to you. Well, thanks very much for having me. All those groups, it's amazing that, lawyers are famously argumentative, and all these different groups of lawyers have agreed to host this event on a topic that is both timeless and timely, I think. Now, I want to start with the one question that I think decides this whole dispute, whether you're an originalist, a functionalist, or simply a lawyer who cares about who is answerable when the government does something. So when a federal law is executed, when enforcement choices are made, when investigations are opened or closed, when regulations are promulgated or applied to private parties, who is responsible? Where does the buck stop? The Constitution's answer is not a commission or an expert board or an independent island or entity of discretion. Article 2's design points to one nationally elected official, the president. So my claim is simple, and I think constitutionally modest. Whatever you think the scope of executive power is or should be, the discretionary execution of law must be responsive to the president, because the president is elected to head that branch and is accountable to the people. If executive discretion is insulated from presidential supervision, we don't get some sort of utopia neutral administration. We get unowned power and worse, untraceable blame. So, three clarifications up front. I just outlined kind of the nut of my argument, but three clarifications. First, I'm not arguing for lawlessness. The president is and should be bound by constitutional and statutory law. Checks and balances are great. What we're talking about is who controls, who directs the executive branch. Second, I'm not arguing for expansive presidential power. The scope of that power and executive branch power more broadly is a separate constitutional and policy question. Third, I'm not arguing that the president personally has to decide every matter in the executive branch, like Jimmy Carter with the White House tennis court schedule, right? Unitary, in my sense, means unity of responsibility. The chain of supervision ultimately runs to the one person the electorate can replace. So let's start with the constitutional text and structure. Article 2 vests the executive power in a president. Then it assigns the president a duty. He shall take care that the laws be faithfully executed. That pairing, that singular vesting with a singular duty, has a straightforward implication. If the president is constitutionally charged with faithful execution, then the president must have constitutionally adequate authority to supervise those who do the executing. Otherwise, you kind of get a very strange separation of powers, responsibility without control. And the discretion point is unavoidable. Execution is not robotic. We don't have some sort of scientific administration that as long as you design the algorithm correctly, it's at that point you don't need any human intervention. Any executive system must make judgment calls. How to allocate limited resources, what violations to prioritize for investigation, what enforcement posture to take, what settlements to accept, what compliance burdens to emphasize, what litigation positions to adopt. You can, the list is infinite of the decisions and the discretion that come within the executive power. If those choices are meaningfully insulated from the president, then the president can't take care, again, his oath, his duty, in any meaningful sense. He can only take blame. And that's why the unitary executive claim is best understood not as a power grab, but as a design for democratic control. The public needs to know who is executing the laws in its name. Let's turn to founding era reasoning. Federalist 70 is the most direct statement of the rationale for a single executive. And it makes the point that unity in the executive exists to prevent blame shifting and hidden power. Hamilton makes the accountability focus unmistakably explicit. This is Federalist 70. Quote, one of the weightiest objections to a plurality in the executive is that it tends to conceal faults and destroy responsibility. Hamilton then describes the exact pathology of diffuse executive power. Amid multiple actors, quote, it often becomes impossible to determine on whom the blame ought really to fall, and, quote, the public opinion is left in suspense about the real author. Now, that's not just an 18th century curiosity or theoretical relic. It's an operating manual for what happens whenever you create executive decision makers who can plausibly say, don't blame me, I'm insulated, blame the statute, blame the president, blame the agency, blame the experts, right? Hamilton warns that unity can be destroyed not only by two executives, but by vesting power ostensibly in one man while making him subject to the control and cooperation of others. So that line maps almost perfectly onto today's debate or the broader fight in this area. A president who is nominally the head of the executive branch, but who can't actually direct key executive decisions because the law has insulated them. We've created this unaccountable fourth or fifth or whatever branch of government. So the originalist point is not that we need a strong man or that in the modern age the government's gotten so complex that we need a strong man. No, it's that accountability, the basic democratic aspect of our system, requires unity of supervision. Now move from Publius, from the Federalist, to early constitutional practice and interpretation. In 1789, when many framers were in that first Congress, Congress asked whether the president could control executive officers. James Madison, in that House debate, frames the issue in terms of the nature of executive power and supervision. He says, quote, "If any power whatsoever is in its nature executive, it is the power of appointing, overseeing, and controlling those who execute the laws." That's basically the unitary executive theory, the principle in founding era language, oversight and control of law executors. And then Madison's letter to Edmund Pendleton makes the accountability argument even more pointed. He objects to Senate involvement in removal, says that's just up to the president because involvement by the Senate, quote, "destroys the responsibility of the president." And he describes the president as, quote, "at all times impeachable and periodically eligible by the people at large. Therefore, quote, the most responsible member of the government." Now, notice what Madison is doing. He's not saying trust the president. The people in their infinite wisdom have elected somebody and then that person just gets carte blanche. No, he's saying make someone responsible. And in a republic, that someone must be the person answerable to the people. And so that's the point. Control tracks accountability. In other words, elections must control execution, not just legislation. So just as elections, represent elect the lawmakers who create the law, elections also control the law executors. Here's the basic accountability syllogism and why it's even those who disagree bitterly about the scope of executive power, which again is not our debate discussion today, but even they should agree with me on who wields it. So first, I'm going to run through kind of a straightforward logical syllogism. First, in a democracy, voters must be able to reward or punish actual governance. Second, in modern government, what affects people most is how laws are executed. Enforcement, licensing, adjudication, settlements, guidance, prioritization. Third, execution necessarily involves discretion. And therefore, fourth, if elections are to mean anything, that discretion must be traceable to an elected executive, the president. If you sever the chain, you don't depoliticize power, you depoliticize responsibility. And that's how you get government by no one in particular. Now, I readily concede what reasonable people can and should worry about. Discretion can be abused. But the constitutional answer to discretion can be abused isn't, therefore, make it unaccountable. It's make it owned by someone answerable and constrain it by law, transparency, and judicial review. So the modern doctrinal fights often use removal protections as a proxy for supervision. But the point isn't removal, it's the control, the presidential control. If the president can't remove or direct senior officers who exercise executive power, then the president's ability to ensure faithful execution is impaired. So it's not a matter of just kind of arbitrarily being able to remove people out of caprice. It's saying, this is my policy, this is my agenda, you're not executing it, so I'm going to remove you and replace you with someone who will. The Supreme Court has repeatedly treated presidential control as constitutionally relevant in disputes over agency structure, especially where agencies are led by officials insulated from removal. And that issue is live right now. Trump versus Slaughter, right? The court just heard argument a couple of months ago on whether the FTC removal protections violate separation of powers and therefore whether Humphrey's executor should be overruled. But secondly, whether a court may order reinstatement of a removed official. Whatever the court does there or in any other case, the constitutional anxiety is the same. Executive power that's not accountable to the elected executive. Let's take some historical examples. I know I only have a few minutes, but let's rattle off some historical examples to make this less abstract and theoretical. Truman fires MacArthur, right? April 1951. President Truman relieves General Douglas MacArthur of command because MacArthur has overstepped his authority, defied direct orders, and interfered with Truman's policy in Korea. Now, whatever your views about the Korean War, the separation of powers point is straightforward. The country can't have a roving executive power exercised by an official who's not electorally accountable and not responsible to the president. Move ahead a few years, but not too much. Little Rock in 1957. Federal courts ordered desegregation after Brown v. Board. Arkansas officials resisted. President Eisenhower issued an executive order reciting that obstruction hinders the execution of the laws and authorizing federal action to enforce court orders. Two unitary executive points here. First, execution often requires speed, clarity, and a single responsible decision maker. And second, when the executive branch enforces constitutional rights, it matters that the public can identify who made the call and hold that person responsible. Third, the independent counsel experiment. This is the opposite, where insulation traded away accountability. After Watergate, Congress passed the Ethics in Government Act, creating an independent counsel regime. This law vested an outside prosecutor with full power and independent authority over DOJ functions. Justice Scalia, you might recall, was the lone dissent in upholding that law in Morrison versus Olson in 1988. And the effect of that, a CRS report found, was that the scope, cost, and effective investigation helped lead to the law's expiration and non-renewal, after which DOJ replaced it with special counsel regulations intended to balance independence and accountability. And DOJ's own testimony captured the accountability critique directly. The independent counsel, compared to ordinary DOJ actors, is not meaningfully subject to usual restraints and limitations and provides insufficient accountability. And the fourth one, real quick, is COINTELPRO, the FBI maintaining a counterintelligence program in the mid-50s through early 70s to surveil, infiltrate, discredit, disrupt various political actors and organizations. And the Church Committee, a Senate Select Committee, later found that the consequence of this decision was to take the law into its own hands, the agency to take the law into its own hands for the greater good of the country, divorced from the unitary executive lessons. So I think I'll stop there. I have some pre-buttals that I had prepared, but given that I'm running out of time, they'll become true rebuttals if I've correctly anticipated what Steve is saying here.
Thanks, Ilya. I think we lost our clock there, if Tiffany can try to find it, but you ended pretty much right on time. So I appreciate that. And we will hand it over to Steve for his opening statement. You're on mute, Steve.
I've been doing this long enough that you would think I wouldn't make that mistake.
We never
Deep
learn.
apologize to everybody. So thank you, Ilya. Thank you, Elisa. Thank you, Tiffany, and all the organizers of this program. It's a real honor and pleasure to be with you all today. I appreciate the opportunity, and as always, appreciate hearing Ilya's perspective and discussing issues with him. And I also appreciate the music at the end of the time. I don't know if everybody heard that, but I certainly did. What a fantastic feature. I'm going to try to keep to my own time, but if the music crooks me off, I will happily go. So where I want to start actually is in 1935 with the Humphreys Executor case. In that case, a unanimous Supreme Court, again, I'm going to say unanimous Supreme Court, upheld the for-cause removal protection for individuals on the Federal Trade Commission, a commission that the court described as having sort of quasi-judicial and quasi-legislative functions. The court said that there's no constitutional problem with the for-cause removal provision for those individuals. Again, a unanimous Supreme Court in 1935. Now, it might not be so surprising that the Supreme Court would have ruled that way in 1935, or for that matter, at any other time in our country's history. After all, if you look at the text of the Constitution, it seems to support Congress's authority to create that kind of institution, pointing to the Necessary and Proper Clause, of course. In Article 1, Section 8, at the very end, if you read all the way to the end of Article 1, Section 8, you'll see the necessary and proper clause, which we often talk about in terms of Congress's authority to enact legislation to the end of its enumerated powers in Article 1, Section 8, which gives Congress some power to enact legislation that is unenumerated in Article 1, Section 8. But if you read to the end of the necessary and proper clause, it says something else. What it says is Congress also has the power to implement law that's necessary and proper to bring into power, to fully flourish the powers in any area of governance under the Constitution and in any office in governance in the Constitution. And so Congress, drawing on this authority, can create offices like independent offices at the FTC or other independent offices across government. And moreover, if you read other portions of Article 1, Section 8, you'll see this thing that allows Congress to spend money. Congress can spend money, and it does. It allocates money to different agencies, reflecting congressional priorities for the work that those agencies do. And then finally, in Article 1, Section 8, Congress has the power to regulate, and Congress delegates that power to agencies that it creates and funds and gives direction to and gives priority to. And so Humphrey's executor, in saying that Congress could design a Federal Trade Commission with commissioners who enjoy some independence and just a modest amount of independence, they can't be removed for cause from the president, that there's really no problem with that under the necessary and proper clause and Congress's spending power and its regulatory authority. Congress can create agencies like that. It can vest them with authority to enforce the law, and it can fund them so that they can do their job. That's all clear in Article 1, Section 8 of the Constitution. There are other reasons why we might not have been surprised in 1935 that the Supreme Court would have upheld the Federal Trade Commission as it was constructed at that point. If we go back to the founding era, the founding era contains a number of different debates at or around the founding, and we can go into more details of these in Q&A if folks are interested. But every single day now, it seems that scholars are coming out with new work saying that founding era sources were ambiguous at best in suggesting that there's a unitary executive that has plenary control over the goings-on in the executive branch. What these sources say is that founding era discussions, founding era statutes, founding era offices that were created by Congress, that all of these things suggest that nobody really thought that there was a unitary executive in the way that we use that phrase today. And what I mean by that is a unitary executive that exerts plenary control over what goes on in the executive branch, that in founding era material that's ambiguous at the very, very best. And in particularly, if we look at things like, for example, Federalist 39 or Federalist 77, there's pretty clear evidence in those documents that Madison and Hamilton, respectively, did not view the president as having the kind of unitary power that some would argue the president has today. So in 1935, again, in Humphrey's executor, it's hardly surprising that a unanimous Supreme Court would uphold the Federal Trade Commission. And then over the next 50 years or so, what we saw is scores of federal agencies emerging, created by Congress, vested with authority by Congress, and funded by Congress, all using Congress's power under Article 1, Section 8, including the necessary and proper clause. Scores of these agencies emerging, and through a process that we call liquidation then over the next 50 years, all branches of government seemed to fully accept the idea that Congress could create independent agencies within the executive branch. Then in the 1980s, something surprising happened. In the 1980s, a group of folks came together and they said, we're really going to take issue with this idea that Congress can create independence within the executive branch. And I think what was going on is in the 1980s, they saw their advantage, their political advantage in the presidency, and sought to expand the power of the president themselves in relation to the administrative agencies and ultimately in relationship to Congress, and started to develop this unitary executive theory. In 1988, it got some play at the Supreme Court in a case called United States versus, Morrison versus Olson. And in that case, there was just one justice, as Ilya had mentioned, Justice Scalia, who set out this sort of robust unitary executive theory with regard to the president's power to remove an inferior officer from office, at that point, the independent counsel. But I say that just to emphasize kind of how modest this was at that point. So the unitary executive was coming out by a single justice on the Supreme Court to say that the president had unitary authority and plenary authority to remove an independent counsel, an inferior officer, even without cause. And so we've got a very modest version of a unitary executive theory gaining just one vote on the Supreme Court. Over time, what we saw is this group of individuals pushing harder and harder at the unitary executive theory, generating scholarship, working in politics, working to get judges on the bench. And by 2010, they had succeeded a little bit in the free enterprise case, testing the Public Company Accounting Oversight Board, an entity that Congress designed to work within the Securities and Exchange Commission. And in that case, the Supreme Court, a very closely divided court, 5-4, ruled that the PCAOB, as it was designed as an independent agency within an independent agency of the Securities and Exchange Commission, violated the separation of powers and impermissibly encroached on the president's authority to remove officers at will. This was a version of the unitary executive theory that gained now 5 votes on the Supreme Court, but again, a still fairly modest version of the unitary executive theory. Well, some people saw the handwriting on the wall and kind of took this idea of unitary executive theory and expanded it dramatically. Expanded it to mean not only does the president have plenary control over officers and inferior officers within the executive branch, but also over civil servants within the executive branch. And maybe not even over just civil servants in the executive branch, but over the executive branch itself. And not just the way the executive branch executes the law, but whether the executive branch executes the law at all, or whether the executive branch spends appropriated funding, for example. And so in the first Trump administration, what we saw is a president, President Trump, who was supported by a robust unitary executive theory enabled by the Supreme Court, and took it in kind of fits and starts to a new extreme. What we saw is doing things like implementing Schedule F, which created a whole new class of individuals in the civil service who were removable at will. And at that point, President Trump pretty clearly indicated that he wanted to politicize a good portion of the civil service, at least those that he deemed in policymaking functions in this new Schedule F. Now, he did that, and the Biden administration rolled it back, and the Trump administration and the first Trump administration, again, kind of moved in fits and starts, sometimes checked by Congress, sometimes checked by the courts, sometimes not checked at all. But my point is, in the first Trump administration, what the administration tried to do is build on this unitary executive theory that had been percolating in some circles and had been developing at the Supreme Court since 1988 in Scalia's dissent in Morrison versus Olson. Well, in 2024, the landscape changed dramatically. Remember, in 2024, the United States Supreme Court issued a ruling that gave all but categorical immunity to a president for almost anything that a president could possibly do. And if they weren't immune on the face of it under the ruling gave a kind of roadmap for any president who wanted to get immunity for any action whatsoever taken while in office to get entirely immune from that behavior. Along the way, the Supreme Court read in a really robust sort of authority that the president has under Article 2 of the Constitution. The Supreme Court called this the president's conclusive and preclusive authority, signaling that there were a number of things in Article 2 that the president could do without congressional oversight or without judicial oversight. What that meant is that Congress could not write laws in certain areas to restrain the president, and in particular, Congress could not enact criminal laws. that would restrain the president. Well, this gave the new Trump administration, the second Trump administration, the green light to expand this unitary executive theory even more. What the new Trump administration said was the unitary executive theory doesn't mean just that the president can fire any officer or inferior officer at will in the executive branch. No, not just that. It also means that the president can fire any civil servant in the executive branch for any reason whatsoever, notwithstanding civil service protections, notwithstanding collective bargaining protections, or other statutory protections that civil servants might enjoy. And not just that, that the president can direct officers and inferior officers and civil servants to enforce or critically not to enforce federal law in any way that the president saw fit, and that the president could actually direct them to engage in what amounts to illegal behavior. Moreover, that the president could impound validly appropriated federal funds and redirect spending in validly appropriated federal funds. You see, what happened in the second Trump administration is the administration built on a trend line that it saw building at the Supreme Court, sort of supercharged by the immunity ruling in 2024, and then just kind of went crazy with it at that point. And by now, the administration has a Congress that is fully supportive, a Supreme Court with 6 justices who have seemed to sign on to some version of the unitary executive theory, many of whom probably sign on to a pretty robust version of the unitary executive theory. And so while the lower courts so far in the Trump administration have largely provided a kind of bulwark against presidential abuse, the Supreme Court, time and time again, mostly on the shadow docket, has given the Trump administration sort of an extraordinary stream of victories on the shadow docket without very much explanation. And so I'll just say this, that this is a little bit like the dog catching up with the car. I think what happened is that unitary executive theorists kind of ginned up this theory in the context of presidential authority over inferior officers. The logical extension of it now is being fully realized in the second Trump administration. And I think a lot of folks are having kind of buyer's remorse at their first buy-in of that unitary executive theory and thinking, what do we do with this now? And with that, I'm going to end it. Thank you very much.
Thank you so much. Before we proceed to rebuttals, I just want to remind the audience that there will be a Q&A section, and there's a Q&A button at the bottom of your screen where you can submit questions. So if you have questions, get started on dropping them in there. And now we will move it to Ilya for a 3-minute rebuttal.
Yeah, I'll pick up where Steve left off. First of all, I don't think we want to argue here about any particular or kind of generalize about the actions of Trump 2.0, because if this administration is doing all sorts of things we don't like, either as a matter of law or policy, it doesn't mean that we can then warp executive power in one way or another or apply theories differently. So regardless of what we think of what the Supreme Court, how it's ruling, or what the Trump administration is doing, should not affect your thinking about whether the executive should be unified. I mean, imagine it's a president that you like and all the policies you like, and you have a court that's different or whatever. Again, we're looking at what executive power properly is. And Steve, in discussing this, started with Humphrey's executor, which was a unanimous Supreme Court opinion, because the court at the time saw the Federal Trade Commission as acting not in a purely executive manner. There was a quasi-executive and a quasi-legislative and a quasi-judicial component to what it was doing, and that's why the president, the court said, shouldn't be able to freely hire and fire its leaders. Even on its own terms, we're now litigating whether that tradition holds with respect to the FTC or any number of alphabet agencies. And we saw a separate argument over the Federal Reserve and why the Federal Reserve may or may not be different than those other agencies. So I think as we've seen the modern administrative state play out, it very much is part of the president's agenda. And while we may like other actors to check this or any president, we only have three branches, so we can't have that democracy deficit or the lack of legitimacy if the president isn't controlling those bits of the executive branch. With respect to necessary and proper, absolutely, Congress can create offices, set duties, but it can't create executive power that's effectively unowned by the president. Madison's 1789 framing treats overseeing and controlling those who execute the laws as executive. It's kind of axiomatic, but I think it's true. If Congress can place execution beyond presidential control, then Article 2 becomes I don't know, formalistic or irrelevant. Um, Next is the problem of, Steve talked about, well, the founding era didn't subscribe to the modern view of unitary executive, and there is robust scholarship disputing strong unitary claims on originalist grounds. I'm not going to go over that. You can look at that excellent scholarship. But here's the thing: my argument is not that every officer must be removable at will in all circumstances. My argument is the more fundamental Madisonian or Hamiltonian point that where executive discretion is exercised, the chain of accountability must run to the president, or else responsibility is destroyed. For that matter, the civil service, it's not that the president should be able to remove every little file clerk, but that the bureaucracy should be accountable to and controlled by those political appointees, which are ultimately accountable to the president.
Go ahead, Steve.
Thanks, Lisa, and thanks, Ilya. I appreciate the reaction. I've just got a couple of points in reaction to reaction. First off, I totally agree and really appreciate, Ilya, that you raised this idea that we can't make constitutional law around a particular president. I tell my class that all the time. If you're going to make constitutional commitments, make sure that they work both ways for folks you like, but also for folks that you may not like in terms of their policy. What I'm saying is not Trump specific. What I'm saying is that the logical extension of a robust unitary executive theory developed by the Supreme Court, developed by advocates over time, and developed by Project 2025, Trump 1.0 and Trump 2.0, the logical extension of this is what we're seeing right now. And I wouldn't want to see this with Trump any more than I would want to see it with Biden or Obama or Harris. This is authoritarianism, and it is a robust unitary executive theory. As to democratic accountability, I completely agree about democratic accountability and like when we have democratic accountability in a democracy. As it turns out, the most democratic branch that we have, political gerrymandering notwithstanding, is the House of Representatives. Our Congress is democratically accountable. And so if Congress is designing agencies and funding them, investing them with authority, and people don't like it, well, they have a remedy: vote them out of Congress. In contrast, the democratic accountability of the president is once removed. And I should think that we would remember that from the 2016 election, where we had a president who lost the popular vote but won in the Electoral College. Where's the democratic accountability in that? And moreover, by all indications, voters did not vote Trump into office in 2024 in order to destroy the federal bureaucracy and promote a robust theory of the unitary executive. So if democratic accountability is what's driving the unitary executive theory, I'm just not sure that it's working. And then finally, with regard to agencies and their responsiveness to the president, what we're talking about here is a very modest control over agencies. All it means is that the president cannot remove certain officers and inferior officers at will. That's all that we're talking about when we're talking about cases like Morrison versus Olson or SELA law or the PCAOB case that I had mentioned earlier. This is, and the Supreme Court recognized itself in Morrison versus Olson, just a modest encroachment on any presidential authority that the president would have over those agencies. What it really means is that a president can't remove officers for political reasons, for sheer political reasons, which is exactly what we're seeing right now in the Trump administration, a move going back to the spoils system before the Civil Service Reform Act and before all the good things that happened in the late 19th and 20th centuries to promote an independent civil service that's a professionalized service.
Thank you. I'm sure Ilya has some things to say about what you just said, but hopefully we can weave them into the question and answer discussion. I'd like to start with a
I love
question.
that music, by the way. It sounds like Mardi Gras. I think we're in Mardi Gras week, so that's
It's
appropriate.
awesome.
Okay, we do have an audience question before I get into some others. How does the Bank of United States history fit into the unitary executive issue? And Ilya, I'll throw that to you since Steve just did his rebuttal.
Wow. That's kind of getting into the weeds. That's very interesting. It goes to President Jackson thought it went against his agenda for monetary policy making. Other presidents disagreed. Good Lord, I'm not, if I hazard a guess based on half-formed recollections, I'm going to get it wrong. So I'll just say that I'll file a responsive brief to that after the hearing.
We've all done it. Steve, do you have anything to say about that?
Yeah, just this. And so listeners may be aware that there are two cases now before the Supreme Court, one testing the constitutionality of the Federal Trade Commission, which is really putting Humphrey's executors, squarely before the court. The other testing President Trump's removal or purported removal of Lisa Cook from the Federal Reserve Board. That case isn't testing the constitutionality of the independence of Federal Reserve Board members. Instead, really what that case is testing is whether President Trump provided adequate due process and had an adequate reason for removing Lisa Cook from office. And so the FTC case is really the one that touches more on the unitary executive. Now, in the FTC case, the Supreme Court earlier in the litigation on the shadow docket allowed President Trump to go ahead and remove the commissioner from the FTC, but wrote in a sentence in its shadow docket ruling that this didn't necessarily answer the question about the independence of the Federal Reserve, which then harkens back to the bank that, Elisa, you had asked about. And so there are some signals that the Supreme Court thinks that the Federal Reserve is different and that the Federal Reserve can be independent within the executive branch. And just to be clear, the Federal Reserve is within the executive branch. There's a sharp dispute about that, whether the current
It could be a functional test in that the Fed, in the way that it handles monetary policy, is actually legislating more than it's executing. But it's certainly a majority of the court, based on that Cook argument, seems to think that there's a distinction, even though President Trump isn't claiming that the Fed is like all the others. He's not claiming at will removal powers. He's, as Steve described, is purporting to remove Lisa Cook for cause, and the dispute is whether he followed, jumped through the right hoops, and who decides what are the standards for what that for cause is.
That's exactly right. And so the question is the current Fed like the Fed that we had in our early republic? And there's an argument that it's not, that the early bank was a purely private entity and designed to be a private entity. And others argue, no, it does look a little bit like the bank in the early 19th century, and therefore that ought to be a kind of precedent for the way the court treats the bank today.
Yeah, to be clear, the court has signaled that it considers the Federal Reserve to be in kind of a class of its own, where they would consider restrictions on removal to be constitutional. Is that right?
Yeah.
And it hasn't been entirely fleshed out yet what exactly those distinctions are, at least to me. But everybody seems to think it's a good idea to keep those restrictions on removal in place, not to politicize the Federal Reserve.
Elisa, I'm not a cynic, but I have heard some cynics say that this special carve out for the Federal Reserve is because there are some justices on the Supreme Court that are concerned about their 401k accounts and other investments. And, again, I'm not going to weigh in on that, but I've heard that.
Many people are saying.
Some have said.
Okay, another question. Proponents of the unitary executive theory rely on the vesting clause of the Constitution that says the executive power of the United States is vested in a president. That's in Article 2. However, the clause does not explicitly say all executive power or exclusively in the president. And the Supreme Court decisions have seemingly been of two minds on whether that adjective should be read into the clause. Do you think that interpreting the clause in that way is consistent with the broader constitutional theory of checks and balances and shared powers? And I want to add a second part to this question, even though it's kind of a whole other can of worms. But in contrast, the necessary and proper clause, as we've said in Article 1, says that Article 1, Section 1 says that all legislative powers herein granted to Congress shall be vested in a Congress of the United States. So it has that word all. Should that clause be interpreted as prohibiting administrative agencies or the president from issuing rules and regulations? Because I think that we can all agree that a lot of these so-called executive agencies also engage in a number of non-executive functions, including adjudication and rulemaking, which can be seen as a type of legislation. So Ilya, I think it's your turn to respond.
Sure,
to both of
sure.
those.
I mean, that's really two questions, but that's fine. So first of all, Congress is given enumerated legislative powers. The American Political Theory 101, there's 17 listed things plus what's necessary and proper for accomplishing those listed ends. The president, on the other hand, isn't given a list of powers. I mean, there's certain things about being commander in chief, but the executive power is understood as the power to execute the law. And indeed, he has the duty, as I quoted, to faithfully execute the law, to take care that the laws be faithfully executed, that the laws be faithfully executed. That means that he doesn't have to be personally executing every law, but he has to ensure that those who are responsible to him because he is overseeing them and making sure that the laws are faithfully executed. So I think it's splitting hairs to say that because the Article 2 doesn't say all executive power is granted to the president, it says the executive power. Because kind of in classical, not just American political theory, executive power, the power to execute, is just kind of it's the background principle, and it's as broad as the laws that are legislated that he has to execute are. It's kind of the flip side. You legislate these laws, the president has to make sure that they're then executed. So I don't think that bears on the issue one way or another. As regard to rules and regulations. In theory, what the agencies are doing as part of the executive branch are executing the laws. They're not supposed to be promulgating new laws or legislating, and that gets us into the very modern debates over the major questions doctrine, the end of Chevron deference, the clear statement rule, all of these things to ensure that what the agencies are doing. And I don't think anyone says the agencies cannot issue regulations, that everything has to come from Congress explicitly. But to ensure that what the agencies are doing there's a direct accountability chain of command to what Congress says under the law, that they're just fleshing out the law, and then what the president is doing in making, as they're doing that they're responsible to him, which is why it's not a problem as such if regulations or guidance or enforcement priorities flip-flop back and forth depending on the presidential administration. That could have, issues of political difficulties, but as a matter of theory, if indeed the president is enforcing and setting enforcement priorities, then having those change shouldn't be a problem, because after all, what the agencies are doing is not legislating, it is executing.
Steve, do you have a response to that?
Yeah, no, substantively, I don't really have anything to add to or disagree with that. I think I agree with everything Ilya said. I do want to remind participants, though, that Congress also enacted the Administrative Procedure Act that directs agencies how they do their work in adjudicating and regulation making, and that agency functions are subject to judicial review in Article 3 courts. And so there is a judicial check on what agencies are doing.
Absolutely. And even if we empower the unitary executive theory, meaning that the president reaches down to the very lowest levels of the bureaucracy, not to fire, again, the point isn't firing bureaucrats. Tenure protections are fine. Civil service protections are fine as a matter of theory under the unitary executive power, as long as the president gets to control what those agencies are doing. The removal is not the key. It's being able to administer according to the president's executive power given to him by the voters.
So neither of you are concerned about the possibility, if I'm hearing correctly, about the possibility that since these agencies really have a mix of powers, including sort of, if you don't want to call rulemaking legislative, but they are fleshing out laws that Congress has created, right? So it's sort of an extension of congressional lawmaking. And there are Article 1 courts that do a fair amount of adjudicating. If all of that power is given to the president, then the president's going to have control over a significant amount of adjudicative and legislative power as well as executive power. Isn't that an awful lot?
Well, I'll just say that we've had cases about ALJs. We had Lucia in the SEC. We had Arthrex with respect to the patent board. And the issue again is control. It's not about whether the president can remove these people and put in his own cronies in a spoil system and things like that. But after all, it's the enforcement actions that the president is responsible for. And so I'm not concerned that at the end of the day, the SEC, the commission, can overrule the determination of an SEC ALJ or its parallels in every other of the alphabet agencies, because it has to be that way, because these are Article 1 courts that have to be reviewable and ultimately accountable. And then what that determination that the SEC makes as a body can and should then be reviewed by an Article 3 court. Again, it's this ponderous checks and balances, but we have to do it that way. And then we can argue about whether any particular actor does it right or not. But certainly, with that responsibility comes again, I'm not arguing for lawlessness. I'm not arguing that the president gets expansive power, period. And the Administrative Procedure Act is a good thing. You can't just have arbitrary rule under our system, whether that's directly by the president or through his underlings. So if our checks are operating properly, and that's a big if, then the system isn't meant to grant the president disproportionate power. There's supposed to be these balances among the branches.
Hmm. Yeah, I don't disagree with any of that, but I would add, kind of what I said earlier, that the Supreme Court has adopted or seems to be in the process of adopting, and I'm saying this based both on removal cases in recent decades, but also its shadow docket rulings in the Trump administration, that it seems to be adopting a pretty robust theory of the unitary executive. And if you do that, you accept the logical consequences of that theory, which would allow the president, according to the president's OMB, for example, to impound federal money or to reprogram it, even though it's been validly appropriated, or to shut down entire administrative agencies, or to summarily terminate hundreds of thousands of civil servants without due process. That just scratches the surface with the things that we've seen in the Trump administration so far. But effectively, to engage in lawlessness of the type that Ilya says, I think quite rightly, and I agree with him, we should not sanction, but the unitary executive theory does.
I don't think that's right. I don't think that's right. And what's going on it's not quite the shadow docket anymore. It's very public. We all talk about it. We know what's going on, but it's, whether you call it the interim relief, it's not quite the emergency docket either, right? Because technically slaughter is off of the emergency docket and we're on to month 3 of deliberations. So interim relief is kind of awkward, but it's kind of the more technically accurate way of looking at these things. And it seems like where the court is going, we don't know, because the other shoes have not dropped yet. The birthright citizenship case, Slaughter, certain others. When we get to the merits, it seems like the court is, I agree with Steve, adopting unitary executive for the president's own reorganization of the executive branch. But once that gets into invading the prerogatives of the other branches, whether with respect to, the president hasn't tried yet. He's trying to do as much as he can, closing the education department, for example,
Right.
farming out certain parts of its functionality to other departments, why shouldn't the Treasury Department be able to administer student loans? That should be okay, I think, within the executive branch, but you can't close down the thing altogether. Or when somebody is impeding somebody's constitutional rights and due process protections, the court says, we have to step in and make sure all of that is checked. And that's where the battle lines are over these things. It's a robust view of the executive branch and the presidential control of it without necessarily speaking to the overall size and scope of governmental powers.
Okay, I have an audience question. Or a comment really, the laws that Congress passes are often vague so that all of the practical decisions need to be made by one or more of the agencies. Not sure how this fits in, but it seems that the responsibility for making things concrete has to reside somewhere. I think Ilya, you're saying that should reside with the president. Steve, you're saying that should reside with Congress in terms of political accountability. Am I roughly correct in that?
No, it sounds like it's the opposite because I'm saying that it should reside with Congress. If Congress passes a vague law, that law is unconstitutional because there's no clear statement of when somebody is hurt by that law, then they have nowhere to turn. There's a lack of legitimacy there. That's why I think the court in fits and starts is starting to rebalance separation of powers by forcing Congress to make the tougher calls a bit more and speak with specificity if it wants agencies to do certain things or not, rather than leave big, so let's have the Truth, Beauty, and Goodness Act of 2026. And then when the Deputy Undersecretary of the Interior passes some regulation that hurts somebody, the congressman says, no, I didn't vote for that. I voted for Truth, Beauty, and Goodness. No, accountability should be in Congress. Exactly. But that's a failure of the courts not to do that. And Steve, in effect, is saying, well, maybe it should be well, I'll let him speak, but it sounds to me like what he's saying that this should be more in the agencies, but not with the president necessarily. So that to me sounds like an argument for this independent or fourth branch.
Well, we have the two different questions. One of Congress legislating vague laws that then the executive branch has to fill out, which can be addressed with intelligible principle and the major questions doctrine, et cetera, which is kind of a separate but related issue. And the other about the execution of the laws, which does require a great degree of discretion on the executive side. And in that sense, that does remove it from Congress's domain, right?
Yeah, I mean, absolutely. Sorry. Well, I'll just say that yes, our system does, by definition, the executive power is not robotic. There is a lot of discretion there. To the extent that that discretion has a political or ideological valence, then elections decide that, and otherwise the whole thing is supposed to be checked by the courts.
Checked by the courts is right, and also checked by Congress, again, through the Administrative Procedure Act. And there's one more check that the Supreme Court managed to eviscerate some time ago. But I guess, Elisa, what I would say to the questioner, we really are talking about non-delegation here, not major questions doctrine, although the two are very closely aligned. For myself, and I, speak only for myself, but I don't really have a problem with broad delegations on the part of Congress to administrative agencies, so long as there are checks in place, and indeed there are. Again, the Administrative Procedure Act, and then, we used to have a single house veto over administrative action before the Supreme Court struck that as unconstitutional, violating bicameralism and presentment. If we still had a single house veto or some other kind of mechanism that would allow Congress to check agencies, I think we may be able to structurally build in an additional check on unfettered agency power. But, I just want to be clear, just because the president doesn't have plenary control over what the agencies do, and what I mean is literally plenary control, because the president has a tremendous amount of control over what they do, even with for-cause removal protections, that even if the president doesn't have plenary control, Congress has built in other mechanisms for control and done this in a variety of different ways. And that, the idea of a fourth branch running rampant is just not a reality. And there are political checks on that through Congress.
Okay, one last question, and then we can wrap up. Um, Back to the necessary and proper clause discussion. Again, the necessary proper and proper clause says Congress has power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Isn't the president an officer of the United States?
Well, one would think.
It's unclear. There are strong arguments on both sides. Josh Blackman and his co-author Seth Barrett Tillman have done a lot of work on saying how officers mean those who are kind of under the president and vice president, or a separate question about the vice president. But it's unclear, and it's unclear in general, and it's unclear whether in that clause it refers to the elected officers in addition to appointed officers.
The president is conceitedly different than any other office in the government, and the Supreme Court has recognized that in several different ways. For example, it's exempted the president themselves from the Administrative Procedure Act. It's created the immunities that we talked about earlier in Trump versus United States for the president, although that could potentially extend beyond the president. But it really is based on the unique office of the presidency. But this is something that we're debating, whether the president is in office for the purpose of the necessary and proper clause. I think that's a really important constitutional question.
Okay, I'd like for each of you to just give a closing comment. And if I may ask each of you, both of you touched on your concerns for if the other side prevails, and we'll know more about which side will prevail once the decision in Trump v. Slaughter will come down, or at least there'll be another big piece of the puzzle. But I'd like for each of you to highlight an example of a bad thing, one item in the parade of horribles, if the other prevails. Ilya, the other theory, the other side, the anti-unitary executive side has prevailed for the past, 80, almost 100 years. But maybe you have ideas either about things that happened that were particularly bad or something that might happen in the future. And Steve, if I could get an example from you of what we really should be worried about if the unitary executive theory prevails.
Yeah.
And Ilya, we'll start with you.
Yeah. Steve, I mentioned this, but I was a little rushed towards the end, and Steve talked about Morrison versus Olson and the independent counsel. Scalia was vindicated with his lone dissent in that case. I think it was his second term on the court, and he was seen as an outlier. But eventually, once the independent counsel went after Whitewater and Clinton and all of that, I think there wasn't much appetite on any side to renew that legislation. And then the special counsels that we've had have also run into trouble of people feeling like they're this Inspector Javert, run amok, that divorced from any control. We don't have some sort of Deus ex machina. It's political control all the way down. We don't have some sort of, Federalist 51, men aren't angels. The government, angels don't govern men. And so we have to put in these checks and these accountability levers. And so I'll close where I began. The unitary executive is not a claim about either lawlessness or the scope of either presidential or executive power. It's a claim about democratic accountability for executive discretion. Hamilton warns that plurality and diffusion of officers of power conceal faults and destroy responsibility. Madison says executive power includes appointing, overseeing, and controlling those who execute the laws, and he worries about structures that destroy the responsibility of the president. And so that's the bottom line. However you resolve these hardest edge cases that have come up and others that we haven't mentioned, the Constitution's design points to a certain baseline. Execution has to be responsive to the president, because that's what makes the executive branch answerable to the people.
Thank you, Ilya. Sorry, Stephen.
Thanks, Ilya. And I just want to say, if I don't get a chance, Elisa, again, thank you for your wonderful moderating. Really appreciate it. Ilya, always a pleasure to have these discussions with you. It's a great honor. I appreciate it. Elisa, the question as you posed it is sort of, what do you fear if the Supreme Court gives us a robust unitary executive? And I guess what I would say is we don't have to imagine our fears. We're seeing them every day when we open up the newspaper. The Trump administration has essentially assumed that it has a robust unitary executive power. Again, under the cases that I mentioned, and in particular under Trump versus United States, the immunity decision that grants the president this really robust, inherent Article 2 authority that Trump has taken and really run with it. And so, what can we be afraid of? What can we see? And again, I'll say this, whether it's President Trump or President Biden or Harris or whoever, that we could see a complete politicization of the executive branch, a rollback before the time of the Civil Service Reform Act and going back to the spoils system, where we don't have people hired based on merit. We have people hired based on pure political allegiance, in this case to Trump and to MAGA. And we've already seen Trump take action, firing civil servants in that vein, firing the protectors of civil servants by summarily firing inspectors general and members of the Merit Systems Protection Board, so that there are no protections for those individuals when they're terminated. And then going a step further, dismantling federal agencies entirely, here USAID, for example, and restructuring the federal government in ways that Ilya talked about that Congress never imagined. Impounding federal funds and outright violating federal law. I think all of these are logical extensions of the unitary executive theory, even though it started out as modest. Again, we're talking about a dog chasing that car, and it finally caught up. As to democratic accountability, I guess I'd just remind participants that there is democratic accountability. It's through Congress, and that's not great. I understand that, particularly with partisan gerrymandering and the distortion in the Senate. I understand that. But it's not great through the executive branch either. And we saw that in 2016. We saw that in 2000. This is not a foreign idea to us that our president is not directly responsive to the electorate. And so democratic accountability, I don't think, is a great support for unitary executive theory. And I think all other evidence suggests that there is no unitary executive.
Thank you both so much. And thank you again to our attendees for spending their afternoons with us. This was terrific. I learned so much and really appreciated the very civil debate. Everybody stay tuned, watch the Supreme Court, watch for the Supreme Court's decision in Trump v. Slaughter, and we will see you at our next Civil Disagreements panel. Thanks again.